Good afternoon. My name is Kerry L, and I'm the Deputy Executive Director and Counsel for ConsensusDocs. Thank you for participating in today's 90-minute webinar. Today you will learn about joint venture agreements using the ConsensusDocs 298 as an example. A couple of housekeeping issues. A few days after the webinar, we will email you a link to the recording and a copy of the PowerPoint presentation. You do have an opportunity to ask questions of our speakers today. Please type your questions in the questions box, and we'll address them at the end of the presentation. I would now like to introduce our esteemed speakers, Kory George and Kerry Kester. Kory George is a partner at Woods & Aiken LLP and concentrates his practice in the areas of construction law and commercial litigation. His experience includes advising and representing contractors, subcontractors, suppliers, manufacturers, owners, design professionals, sureties, and financial institutions in all aspects of claim and dispute resolution proceedings at both state and federal court levels. Kory has made numerous presentations before various trade industry groups and professional organizations, and he has also authored a variety of publications. He is an active member of the American Bar Association Forum on the Construction Industry and is also a member of the ABA Litigation Section Committees on Construction Litigation and Commercial and Business Litigation. Kerry Kester is a partner at and has practiced law with Woods & Aiken since 1981, focusing on construction contracting, construction dispute resolution, and counseling of construction contractors, owners, subcontractors, and suppliers. Kerry's experience includes counseling clients regarding claims and dispute avoidance, lien and bond claims, contract negotiations, and project management. He has handled disputes on local, state, and federal projects as well as on private projects. Kerry is a frequent speaker and writer on construction-related topics. He serves on the governing committee of the ABA's Forum on the Construction Industry, is past chair of the Project Delivery Division, and is lead editor of the Forum's Design Build Desk Book. We are very lucky to have such prominent construction industry attorneys for our presentation today. We'd like to start with a very brief overview of ConsensusDocs, and then we'll get right into the substance of our webinar. ConsensusDocs are written and endorsed by 37 leading design and industry and construction industry associations. Since our launch in 2007, we have increased the coalition by more than 75%. We've also experienced consistent user growth despite our down economy. We now have over 100 contract documents addressing all methods of project delivery, and we've had several firsts in our recent history. We did the first IPD contract, the first BIM contract, the first comprehensive green building contract, and in 2011 we did a comprehensive update to the primary agreement, which was advance of schedule. We believe at ConsensusDocs that staying current with leading trends and best practices is a must. And in 2012, we released an entirely new technology platform to assist our users, incorporating Microsoft Word documents in a unique collaboration platform, as well as releasing new contracts, including the 298. Now I'd like to turn it over to Kory and Kerry.
Thank you, Kerry, and thank you everyone for tuning in for this program, and welcome. I think we have a good number of participants here today, so appreciate you all joining us. As Kerry said, my name is Kory George. My partner is Kerry Kester. We're in the same office in Denver, Colorado. We were members of the ConsensusDocs working group that was tasked with coming up with and authoring the ConsensusDocs 298 joint venture agreement that we're going to talk about here today. So that's how we got tapped for this program, and explains to you a little bit. We have some insight as to how that thing was drafted, and we're going to go through that with you here today. As Kerry Filiberto said, there's an opportunity to ask questions on your computer, so please feel free to do that, and time permitting, at the end we are going to answer as many of those as we can. If we get long-winded here today and don't get to all of them or any of them, you can still submit those, and we will we know who is sending those, so we can respond to those in due course after the program. So please feel free to do that. Give you an overview. See if I can give you an overview of what we're going to do here today. We're going to talk about joint venture contracting in general, just briefly, kind of the pros and cons, why you do it. And then the meat of this program is really points 2 and 3. We're going to go through and identify some of the key issues that we see in joint venture agreements, and in particular some of the issues that the working group dealt with in drafting the 298. And then we're going to talk about how those issues are dealt with or addressed in the 298 itself. And so points number 2 and 3, we're going to kind of take in tandem rather than raise all the issues and then tell you how the 298 deals with them. We're kind of just going to raise them as we go through the document and tell you how each of those issues is treated and dealt with in the 298. So hopefully everybody gets something out of this program. My understanding is that it's a free program, so to the extent you don't like it, I think I'm authorized to say you're entitled to a full refund. But hopefully you can get something out of this, and Kerry is going to kick us off with joint venture contracting.
Thanks, Kory. I want to turn now to some background and context for today and look at some of the reasons that joint ventures historically have been a fairly significant tool in the delivery of construction services. There are really a number of reasons for that. Maybe starting with the most recent, one of the reasons that seems to be a fairly popular tool these days in the source of a great number of phone calls that we've gotten in the last 3 or 4 years is the use of these joint ventures in the set-aside programs, the socioeconomic programs at the federal and other levels, which rely on some form of mentor-protege relationship between large and small contractors. The SBA, the DOE, DOD, and some of the other federal agencies rely on the joint venture mechanism as a way to allow large contractors to combine with small contractors for purposes of obtaining these set-asides awards in a manner that does not attribute the size of the large contractor to the joint venture. And so these have been used extensively for that purpose. More generic reasons for the use of joint ventures really fall into a couple categories. One is simply combining the relative strengths of different companies for any number of reasons that can include addressing multiple types of work that may be involved in a single award, improving the qualifications of the offeror, at least in the eyes of the awarding party as compared to any of the individual joint ventures on their own, and the ability to meet unique project challenges. Another common reason that is used for justifying joint ventures is the spreading of risk on large or high-risk projects. Back in the days when we actually built nuclear power plants, a great number of those contracts, particularly in the specialty trades, were in fact awarded on a joint venture, a tri-venture, or other multiple party entity arrangements. And the primary reason for that was spreading the risk of those projects and being able to muster sufficient resources to perform them. Another perhaps less publicized reason for using joint ventures involves the implementation of some of the more advanced project delivery methods, including design build or variations of integrated project delivery, where the joint venture approach is consistent with the collaborative delivery of a project. And in terms of, go ahead. On to the next slide. In terms of real advantages of the joint venture entity over other forms of business combinations, you probably can certainly count all those things we've just talked about as potential advantages. But additionally, there are some real practical advantages to the use of joint ventures. First of all, the ease and simplicity of their formation and maintenance. There's a lack of statutory or regulatory formalities. Typically, few, if any, filings required to organize a joint venture can be done simply as a matter of agreement, even on an oral basis, although we don't recommend that, obviously, or we probably wouldn't be having this phone call. So ease of formation and the ease of maintaining it certainly is one advantage. Additionally, another advantage, predictability in terms of the legal implications. Joint ventures historically have been treated through the use of partnership law principles, and as a result of that, boards, courts, arbitrators, and decision makers in disputes are familiar with those principles, understand them, and understand how they apply to joint ventures. So it adds a level of predictability that may not be there in regard to other types or other types of entities. They're flexible as well. You can adapt joint ventures to many different uses and certainly incorporate any range of different financial liability sharing and profit sharing concepts into these agreements. And finally, I think they're presumed by most people to be for a limited purpose and limited duration. And I think that can be an advantage in the sense that people are comfortable with them, even though they understand that they may not be in existence 5 years down the road. Folks are comfortable with that, and it doesn't raise any particular flags. Like everything, of course, there are disadvantages to joint venture contracting, and one of the things that we just mentioned as an advantage also can be seen as a disadvantage, and that's the application of partnership law principles in the form of joint and several liability to third parties for partnership debts or liabilities. And that of course, certainly seen as a downside by some folks. But another thing that's perhaps a little less obvious is the inherent exposure of company confidential information, trade secrets, processes, and other information that's sensitive to companies. Over the course of performance of a project that may go on for months or even years, it's inescapable that there's going to be exposure to this type of information, and so there's a legitimate concern really of all the parties involved in a joint venture relationship as to how they manage and maintain the confidentiality of the information that is exposed and disclosed to the other parties. Typically, that's handled, through some type of confidentiality provision or even separate confidentiality agreements in some cases. Another aspect that is worthy of consideration here is the fact that adding a joint venture as an entity really adds another layer of financial, personal, and reporting relationships to what can be an already stressful environment. And certainly we've all seen situations where that turns adversarial and leads to possibly even to disputes. Similarly, differences in philosophy and personality certainly lead to the same types of conflicts or disputes, particularly where the joint venturers are not well acquainted with one another, and perhaps their personnel have not worked together on other projects. So one of the things that there you go. One of the things that we with that context, think that we've been able to do in the 298 is to really successfully, I think, account for many of the disadvantages and at the same time leverage many of the advantages of joint venture contracting. At least that was a goal that we had going into the project. And now as we turn our attention to some of the key issues in joint venture agreements, you'll see, I think, the first bullet point there is what if there's no written agreement? And I'll have to tell you, after 30 years of this, I still get asked from time to time, why is it necessary to have this written contract? Or even if it is, why does it have to be 10 or 15 pages long? And typically my smart aleck response to that is the fact that I bank on contractors becoming clients because they ignore contracts. But really, when you get down to looking at it, I think the key to the success in this area is having an effective written agreement that accurately states the rights, remedies, and duties of the various parties involved, and that, of course, is the impetus for development of the ConsensusDocs 298 agreement. And so Kory now is going to take us through some of the background for that document.
Yeah, just to give you a little bit more context on the 298, you know, there was no doubt that we saw an increased use of joint ventures regardless of the reason and the pros and cons. It was obvious that folks in the industry were using them. And so we formed, the ConsensusDocs formed the working group in February of 2011 and looked at the existing approaches that were out there. Again, we identified some of the issues and then came to the conclusion pretty quickly that the industry could really benefit from a new form in this area. And so we set out to start drafting the 298, or what is now the 298. And as Kerry said, I mean, there were two kind of goals that we had in mind as we undertook that process. One was to deal with these issues or the disadvantages and the hot button topics that we saw from joint ventures, to deal with those aggressively and specifically, and we did that through making certain assumptions or having certain default settings, and at the same time, you know, having done that, we didn't want to lose any of the inherent flexibility or the advantages of joint ventures. So we kind of had those two things as competing guideposts as we drafted this thing, and so I think you'll see that as we work through it here today, where it addresses some of these issues in detail, but yet it's flexible enough to do something else depending on the situation. And so that process took about 15 months from the time we set out to start drafting to the time that the form became available for purchase, which I think was in June of this year. So it was a long process, but I think we're pretty pleased with how it came out. And we didn't hand out a copy of the agreement, for purposes of this seminar. And we're not going to put wholesale provisions on slides and read them to you, but as we work through it, we're going to reference certain article numbers, not that you need the agreement next to you to understand it, because we're just going to go through it conceptually, but those are going to be in there, so if you have it or you get it, you can cross-reference at a later date to some of the things we're talking about here today. Just as one other side note, we're talking today about joint venture agreements, in particular the 298. One thing to note, after we got done with that, we quickly realized that sometimes, less often, but sometimes these things take the form more and more these days in the context of an LLC. And so there is a separate document that is forthcoming. The 299, I believe, is the number, but it deals with these same issues that we are going to talk about here today, but only in the context of an LLC and the issues that are unique to that entity. But just to note that that's out there, we're going to talk about the 298 today. Let's see if I can. Oops. I'll let this catch up. In looking at the key issues that we had to deal with, there were a number of them, dealing with just the scope of the agreement, dealing with partnership law principles that Kerry talked about. Indemnity was always a big issue. The use of the so-called line item joint venture, there was a lot of push to deal with that or to incorporate that. Voting requirements was a big topic. What happens in the event that one of the joint venturers defaults or fails to fulfill its obligations? What happens? How do you deal with that? And then just forms of dispute resolution for handling disagreements. There was a laundry list of about 50 issues that surfaced in the course of identifying what the key issues or the hot button topics were. And basically, at the risk of trying to oversimplify it a little bit, most of those issues could be distilled down to one of 4 categories. And those are listed there. The operational aspects is one category. The internal management of the joint venture itself. Obviously, risk allocation with indemnity insurance and bonding and other issues, and then just defaults and remedies. And so that's kind of the format we're going to use to work through the agreement. Dealing first with the operational aspects. In here, a subset, again, a scope of the agreement, who's going to be performing the work, and then something that's on everybody's mind is, how do we get paid and when. So looking at that, the scope of the agreement, Article 1 of the 298, it makes an assumption that it's a tri-venture. Frankly, that there are 3 joint venturers that are going to be parties to the agreement. But it can work and is made to work, if you just have 2 joint venturers, which is often the case, it works just fine for that. Frankly, if you wanted to have 4 or more, it works fine for that too. So it assumes 3, but it's easily adaptable to any number of joint ventures. So there was an example where we made an assumption but kept it flexible. Article 2.1 was a big topic that we dealt with. Most of the joint venture agreements that we looked at didn't address adequately, if it addressed it at all, the proposal stage of the project. And it frankly, most of them assumed that a contract had been awarded, which in our experience and in the experience of the working group is typically not the case. And so one thing we did was the 298 deals with the relationships and the responsibilities at the proposal stage. And the proposal can take any form, whether it's a competitive bid or a negotiated bid or whatever the format is. It works just fine in the 298, but that was a big change that we thought was a good change, and it's in the 298 that it deals with the parties at the proposal stage. If the contract has been awarded already, the 298 still works fine. Again, it's flexible in that regard, but it does account for the submitting a proposal to the owner. Again, Article 2.3, it has a limited scope. It's confined to a specific project. There was some discussion of, geez, what happens if we're chasing companion projects? Ultimately, it was decided that the best practice of this was to treat each project separately. You could make the 298 work for multiple projects, but it is designed for a specific project. And the group thought if you had more than one project with a team member, that you execute a separate agreement for each project. Again, dealing with some of the partnership law aspects, the joint venture is assumed to maintain its duration until one of a certain number of things happen. One is if the proposal cannot be agreed upon by the joint venturers, that would trigger frankly a dissolution of the joint venture. If the contract is awarded to another entity and all bid protests and that kind of stuff have ended, then it would trigger that dissolution. Or frankly, you get the contract and you finish it, then that triggers the dissolution of that. And that was important because one of the rules in the 298, again, just embracing the partnership law aspect of things, is that once the agreement is signed by the various joint venturers, everybody's in it until the joint venture is dissolved. So in other words, once you sign up for this, you cannot withdraw or disassociate from the joint venture. You have to go through the dissolution and unwinding process, and frankly, that's the default rule in most places anyway that deal with joint ventures. And so we thought we would just embrace it, because that's really the gap-filling rules on that with courts anyway. And so that covers the scope of the agreement. Next issue is who's going to be doing what work. One thing in Article 2, the 298 agreement incorporates by reference the owner agreement if it is awarded. And the owner agreement is a defined term in the 298, it just basically means the prime contract, the contract awarded from the owner. That's incorporated, and so we thought that was important because that eliminates any sort of scope gap between the proposal and the owner agreement as among the joint venturers. And so the joint venture as an entity collectively is responsible for everything in the owner agreement, which is the case anyway. And so just to avoid any confusion or scope gap among the joint ventures, we just made that a formal document that's incorporated into the 298. Article 6.1 is an example of where we made some assumptions and then tried to keep it flexible. Article 6.1, the default rule is that the joint ventures are jointly responsible to the joint venture entity itself for the performance of the work. So in other words, everybody puts in for their percentage interest, whether it's 50-50 or 51-49 or 70-30, or if you have a tri-venture, you know, everybody's in for their stated percentage, and everybody is responsible in that regard, win or lose on all those scopes of work. There was a lot of clamoring for the line item joint venture, and we didn't make that a default setting, but we did allow for its use through, there's an exhibit, there's two exhibits to the 298. One of the exhibits, Exhibit A, is in there to deal with this concept of the line item joint venture. And what Exhibit A is there's nothing that magic about it, other than it's a template for the joint venture to award subcontracts to a particular joint venturer. So they put in for the scope of work that they're going to do for a lump sum amount, and then with respect to that scope of work, that joint venture can make or lose money, you know, in its own right, without regard to the sharing of profits and losses as a whole to the joint venture entity. And so don't have to use that, but it's certainly in there to the extent that that's what parties wanted to do. There are some safeguards in there. Subcontracts issued on this line item basis, or subcontracts from the joint venture to a particular joint venturer, the terms of that have to be agreed upon by everyone in the joint venture. And the reason for that is that if someone is a 51% has a 51% interest, they can't write themselves a line item subcontract for cost plus without a GMP. So it's in there. If everybody agrees to the scopes of the work and the amount, it can be done that way. Another last issue on sort of the operational side of things is payment. And the way that is set up is under Article 6.3, each of the joint venturers bills the JV entity monthly for its costs recognized under Exhibit B, which we'll talk about in a minute. That's the other exhibit to this agreement. Then obviously the JV turns in its bills or progress payments or payment applications to the owner in accordance with the owner agreement, which, as noted, was a document that's incorporated by reference into the 298. There is, with respect to payments, it is based on funding being available and paid by the owner pursuant to the owner agreement. So to the extent that that money is available, payments are to be made to each joint venture within 5 business days. If money is not hasn't come in from the owner, it's a pay when paid concept as to each of the joint ventures in terms of their reimbursable and recognized costs. Dealing with this Exhibit B in particular, Exhibit B is it's a pretty handy document. We've got some help in drafting that from some construction accounting and CFMA type folks who is a member of the coalition, and so a good deal of thought was put into that. But to boil it down, basically what it does is Exhibit B says the joint venture is going to pay third parties, vendors and suppliers and subcontractors, which could include a subcontract to one of the joint venturers under Exhibit A, that line item concept. So they're going to pay those bills as, for what the amounts that they're owed. And then with respect to payments to the joint venturers themselves, that's subject to some cost recognition requirements. And basically what those requirements are is just the costs have to be reasonable and substantiated, and obviously they have to be related to a cost that's incurred as part of the owner agreement, and costs that are reimbursable under the prime contract or the owner agreement are similarly reimbursable to the joint venturers. And then it goes out and it talks about other costs, and these are primarily costs of the joint venture. If it has employees, obviously those are payable wages of, if there are any employees of the joint venture itself. And then there are some costs that are specifically excluded that you cannot get or bill for. And these are costs of submitting the proposal, home office overhead of a particular joint venturer, and obviously things like if there's a dispute amongst the joint ventures, you can't claim your legal fees as a cost that's reimbursed from the joint venture itself. But all that's pretty self-explanatory. I think it does a good job of just setting some parameters on what are the costs that are going to be recognized and payable by the joint venture to the joint venturers and other parties in the agreement. And with that, I'm going to turn it over to Kerry for the next topic on internal management.
Thanks, Kory. As with other aspects, of the 298, its approach to internal management, I think, reflects the flexibility and cognizance of the joint venturers' potentially differing interests, while at the same time honoring one of the ConsensusDocs principles of making sure the job gets done. And in that regard, I want to look at some of the key issues that dealing with internal management as we go through here. The basic management structure as it defaults to the executive committee under the 298. And the executive committee is comprised of one representative from each joint venturer who together form the executive committee. The executive committee then has some enumerated responsibilities and duties, one of which is to appoint a managing joint venturer. That title and that office also has some defined responsibilities But in addition to that, we have the concept of the project manager, which is also appointed or named by the executive committee. Let's look first at the executive committee, and these provisions are found in Article 4 of the 298. And in Article 4.1 provides for the naming of the executive committee at the time the joint venture agreement is executed. It charges the executive committee with approving, such things as approving the budget, approving the project construction schedule. They're charged with negotiating the terms of the owner agreement and negotiating the terms of any subcontracts, purchase orders, or other agreements that are necessary to carry out the completion of the work. Article 4.3 then sets out and covers the manner in which the executive committee will make decisions and the nature of the decisions that are reserved to the executive committee. And then Article 4.5, kind of as an adjunct to that, allows the joint venturers to reserve to the executive committee certain responsibilities that they view as being non-delegable. That is, they can itemize in Article 4.5 those types of decisions or topics on which the executive committee is not authorized to delegate decision-making responsibility either to the managing joint venturer or to the project manager. In terms of decision-making, the 298's philosophy really is to encourage consensus and unanimity in the executive committee. But like many other aspects of the agreement, we have a default position, which is that voting based upon percentage of interest is the rule. That is, percentage interest is a term that's defined earlier in the agreement, and basically it's based upon the financial interests of each of the parties. But that also then determines their voting power as an executive committee member. Article 4.3.2 then identifies several actions of the executive committee that require unanimous consent or unanimous approval. And those include things like approval of or changes to the proposal that goes to the owner. And in fact, there's a provision that terminates the joint venture in the event that there is an inability to reach agreement on the terms of the proposal. Another unanimous vote requirement is for dissolution or liquidation of the joint venture prior to completion of the work on the project. The parties also have the ability to identify a certain level of capital expenditures by the joint venture, which would require unanimous approval. The timing and distribution, method of distribution of profits or assets of the joint venture, as well as Kory mentioned, the approval of the terms of subcontracts let to other joint venturers through the line item Exhibit A approach, also require unanimous consent. The 298 also uses the concept, as I mentioned earlier, of the managing joint venturer, and these provisions are found in Article 4.5. And the managing joint venturer can either be identified at the time the agreement is executed or later appointed by the executive committee as one of its actions. The charge of the managing joint venturer is then for basically the management and supervision of the daily affairs and operation of the joint venture in order to complete the work, always, of course, subject to the superior authority of the executive committee. Among some of the specific duties of the managing joint venture are things like the periodic financial reporting, the management aspects of cost accounting and cost reporting to the joint venture for decision making and management purposes, as well as serving as the tax matters partner for the joint venture. The next layer of management that we get to is the project manager, and that those provisions are described in Article 4.6, which provides for the appointment of the project manager by the executive committee. Here the presumption is that the project manager is human, or at least is a human being. Again, here the agreement is intended to be flexible, and in those cases where a separate project manager may not be warranted, the ConsensusDocs guidebook directs the parties and advises them to consider combining the responsibilities of the project manager and the managing joint venturer so that those are combined into one entity. Among the duties of the project manager, which are set out in Section 4.7, include the preparation of the budget and the project's construction schedule for review and approval by the executive committee, carrying out the work on a day-to-day basis and providing, again, a human point of contact for interaction with the owner. And with that, I want to turn it back over to Kory to talk about one of my personal favorite topics, and that is risk allocation. Kory?
Well, there were no shortage of issues and provisions to deal with in the risk allocation part of this, but chief among them were the indemnity, the insurance and bonds aspects of this, and take you through how the 298 dealt with those issues. With respect to indemnity, the default rule or the presumption is that each of the joint venturers are going to share liability up to their percentage interest, and that is true regardless of ordinary negligence or honest mistakes. And so each of the parties, if one of the joint ventures is just negligent or misses something, then everybody's on the hook up to their percentage interest, and that's the presumption in Article 3.2. There are exceptions to that. One of the exceptions we've talked about, which is the line item concept. If a subcontract is awarded to a particular joint venturer, then they are on their own, win or lose, for that particular scope. But with respect to all of the other obligations under the owner agreement, it's a shared liability up to the percentage interest. Now, the other major exception to that is this concept called wrongful action. If one of the, and there's a specific definition in the agreement, but basically it's the fraud, bad faith, willful misconduct, and stealing kind of things. If one of the joint venturers does one of those things that is deemed to be a wrongful action, they then lose in effect, the limitation of their liability. So if they're in for 50%, they can be liable for the entirety of the damages caused as a result of a wrongful action. And there was a fair amount of discussion and argument over that point and how to, perfectly define what is a wrongful action. Ultimately, the conclusion was things like fraud and bad faith and willful misconduct and those kinds of concepts at least are not foreign to courts and arbitrators. And so, you may not have a black and white answer on that, and that may be left for dispute. But ultimately, it was thought there has to be some carve-out if there is just egregious conduct by one of the parties. The default rule of you're only liable up to the amount of your percentage interest probably was not a best practice result in those situations. Another issue that was probably under the radar for some, but it was a hot button issue in some respects, was this issue of how do we deal with claims of employees of a particular joint venturer. And the way that was handled was the employing joint venturer, that is, someone has someone on the payroll as a joint venturer, not as part of the joint venture entity itself. But with respect to each joint venture's own employees, if they have a claim, the employing joint venture is responsible to indemnify both the joint venture and the other joint venturers from those claims. So that, again, is in the nature of an exception to the limited liability rule that you can only have indemnity obligations up to the amount of your percentage interest. That doesn't apply with respect to claims by employees of a particular joint venturer. And obviously that employee has to be, working on the project and not on the payroll of the joint venture entity itself. And there is a waiver of subrogation as it applies to this particular obligation. Next big topic was insurance, and frankly, if you get into the agreement, what the agreement will tell you is we don't pretend to know the various requirements of the particular project or the owner agreement, and frankly, the normal insurance programs of each particular joint venturer. There's really no good way to account for all of that in sort of a default setting. And so what the 298 tells you to do in the guidebook is you ought to contact your insurance professional and figure this out in detail. And all of these insurance requirements in the 298 are subject to adjustment and setting by the executive committee. So if it's a wrap policy or whatever the case might be, that can all be accounted for and adjusted by the executive committee as part of this agreement. If you have some folks are just going to ignore all that. So for those types that just ignored that the particular requirements and they're just going to go forward, there is a default setting in the agreement. So if you do nothing and the executive committee does nothing, these are the default settings that are in the 298. And what those say is each of the joint ventures is required to get work comp, employer's liability, business auto liability should be in that first sub-bullet point. So each of the particular joint ventures is going to get work comp, employers, and auto. That's what they're required to get. The other default is the managing joint venture that Kerry talked about, whoever that's designated to be, is required to extend its general liability coverage to cover the joint venture entity and each of the other joint venturers. That's how that's handled. And again, if you don't like that, it can be changed by the executive committee. But that's the default setting in here. The joint venture entity itself is required to get builder's risk unless it's provided by the owner, or there's other agreement for that in the owner agreement. But the default is if the joint venture has to get it, it goes and gets it. If there is any professional services or design responsibility that is part of the owner agreement, the default setting on that is the particular joint venturer, if any, that is going to perform those particular services is then tasked with getting the professional liability insurance to cover that particular scope of work. And then if there are other coverages that are either a good idea to have or that are required by the owner agreement, whether it be pollution liability or whatever the case might be, again, that's within the control and purview of the executive committee to procure those coverages or delegate who's going to get those. And all insurance costs, to the extent it's attributable to the joint venture, is a recognized cost under that Exhibit B that we talked about earlier. A couple other points on insurance. As a default setting, each of the joint ventures is required to maintain its own coverages as to themselves. And that is for employers' liability, again, business auto liability. In 9.1.44, in addition to that, which should be included in there, is general liability or CGL coverage and work comp, the usual suspects. Each joint venture is required to maintain those for themselves. For those that are into the insurance requirements of things, the default setting on those is $1 million. Well, it's statutory limits on work comp. And then for the other coverages, it's $1 million per claim and $1 million in the aggregate. And again, those are just default settings. If you don't like those, again, they can be changed pursuant to the executive committee. Can change those either because they want to or because the owner agreement says something else is required. In terms of general requirements as it pertains to insurance, there's a requirement that all of the insurance endorse the joint venture and each joint venturer as a named or an additional insured. That's one of the requirements, and there is a waiver of subrogation against both the joint venture entity and each of the other joint venturers. And again, that's just the default rule. If you're in a state that doesn't allow for that, or the owner agreement says you can't do that, it can be changed easily by the executive committee. They have that authority to do that. The next issue relates to bonds. There it goes. The default rule or the assumption that's made in the 298 agreement is that each of the joint venturers is going to share in the responsibility for bonding up to their percentage interest. So in other words, it assumes that each of the parties is going to put in for part of the bonding. There's going to be cross-bonding, and everybody's going to put in and bond for the up to their percentage interest in this. If that is not the desired result, or is not capable of happening because one of the parties doesn't have the bonding capacity, or whatever the reason might be, then the agreement needs to be modified accordingly. So that's something to pay attention to if you use this agreement. The default rule is everybody's putting in on the bond. If that doesn't happen, then that needs to be adjusted accordingly. Another thing to note in this is each of the joint ventures is joint and severally liable as to the surety. So if the joint venture entity puts in for a bond, and as would normally be the case anyway, the indemnity agreements for each of the joint venturers, this agreement embraces reality that those are probably going to be without limitation to anything. Those are just, well, other than perhaps the penal sum amount of the bond. But each of the joint ventures who signs on for a bond is subject to joint and several liabilities for the full amount, and they don't get that limitation that we talked about earlier. Now, if one of the joint venturers is forced to pay an amount greater than their percentage interest on a claim, a performance bond claim, or whatever the case might be, they would then have an indemnity claim coming back against its brethren for up to, again, the amount of the percentage interest, subject to those exceptions for wrongful actions that we talked about earlier. A couple other risk allocation provisions that we're not going to go into in detail, but we'll just point them out to you that they were thought about and they exist in the 298. Obviously, there's a confidentiality provision in Article 8 that's meant to mitigate some of the the disadvantages of sharing this private information. There's a provision to deal with that. Keeps all those documents and information proprietary, cannot be shared with others. There is in Article 11.10, there is a non-solicitation of employees provision. There's a spot in there where the parties can insert the appropriate duration for that. If nothing is specified, then frankly there isn't such a provision. But if that is a concern where somebody may take somebody else's employees, there's a provision in there to account for that risk, and the parties can state the specified time period of that. Consistent with the other ConsensusDocs documents, There is a waiver of consequential damages provision. So as between each other, there is a waiver of consequential damages. Obviously, there's some exceptions for that. If the joint venture entity signs up for consequential damages as part of the owner agreement and becomes liable for them as a entity, then obviously then those can be spread to the particular joint venturers, but there is a waiver as it relates to and among the joint venturers themselves. There is one other kind of new aspect of this that we saw in some of the other approaches to this. There is a security agreement in the 298 with collateral that's defined in the agreement under Articles 11.1 and 11.2. Each of the other joint ventures as against each other is given a security interest backed by the proceeds of, and the assets as it relates to the particular project. And again, that can all be done and recorded consistent with Uniform Commercial Code principles. But that is a default setting in here that as security against the capital contributions and other obligations that the joint ventures are taking on, they're giving a security agreement to its other team members for the amount of its obligations under the agreement. One other kind of general provision note that's interesting in the 298 is with respect to alternative dispute resolution. We're starting to see that more and more, but in Article 10 of the 298, consistent with some of the other consensus docs documents and approaches, there is a menu of options. It's no longer presumed that you're going to litigate or arbitrate. You've got a menu with a default setting there. So if you want arbitration, you can check that, or you can default to litigation. But in addition to that, there's the concept of, if you want it, you don't have to have it, but you can check it and use it. It allows for the use of a project neutral, which is an approach that you might have seen in some of the other documents and forms. Or it also allows for the appointment of a DRB, a dispute review board. So depending upon the nature and complexity of the project, those options are included in the 298 that can be implemented if the parties are in agreement to opt into those requirements or options, I guess. And with that, we're going to go to the last topic of default and remedies, and Kerry's going to take us home.
Well, if you get to the point where you're reading Article 7, it's probably not a good sign. Obviously, Articles 1 through 6 that we've talked about and some of the other provisions are meant to help you implement best practices in an effort to avoid situations of default and the consequent disputes that can result from that. Article 7.1 takes the approach of identifying a number of actual events of default, much in the same way that you might see in a typical transactional type of agreement. Those include things like the classic material breach or insolvency, misrepresentation, failure to contribute capital. And I'll stop at that point to say failure to contribute capital is something that there was almost unanimous view that needed to be treated with in a very specific and a very serious manner. And you'll see that as you go through the provisions of Article 7, that defaulting in the contribution of capital is something that's not viewed with a very accepting eye. The Article 7.3 lists a number of consequences that attend to a joint venture's default in its obligations, including having no further voice in the joint venture affairs, no vote on the executive committee, no property interest in the assets or profits of the joint venture until such time as the interests of the non-defaulting joint venturers have been fully satisfied. Obviously, though, we do allow the defaulting joint venturer to maintain its normal share of liabilities, however. And then Article 7.2 also then makes it clear that an election of any of the enumerated remedies in the agreement does not preclude resort to other remedies of law by the executive committee. And so the remedies listed there, the point being that those remedies are not intended to be exclusive remedies under the agreement. Article 7.4 then provides some additional consequences in the event of a defaulting joint venturer's failure to make a capital contribution. As I mentioned earlier, this is again something that's addressed with a fair amount of vigor in this agreement. Article 7.5 then provides in extreme cases and only with the unanimous consent of the non-defaulting joint venturers, the executive committee may elect to dissolve and wind up the affairs of the joint venture, and in the event that this were to occur before the award of the owner agreement, the joint venture agreement here allows the non-defaulting joint venturers to go forward and pursue the award of the project from the owner without any obligation to the defaulting joint venturer. So I guess, if the moral of the story is if you're coming to the joint venture party, go ahead and bring your checkbook and make your capital contribution. So the financial commitment's taken very seriously. With that, I guess turn it back to Kerry.
Yeah, I guess just as a parting comment before we get into questions, if there are any. I hope it was evident that the approach that was taken on these issues was, best practices kind of approach. And I hope it was evident that, with respect to some of these issues, there was an effort to allocate with some specificity the risk and responsibilities on the particular topics, but not to go overboard and to lose some of the inherent flexibilities that was one of the advantages of joint venture contracting. And so all in all, we would encourage folks to take a look at it. I think the 298 provides pretty solid foundation from which to enter into these types of agreements, and certainly raises the issues for you. And you can, alter and amend this thing as appropriate, but at least it provides some default settings and some options for you. So I would encourage folks to check it out. With that said, Kerry C., are there any unanswered questions?
We do have a couple of them here, and let's see, one of them is, and I answered it briefly but didn't know if you wanted a chance to elaborate. It says, can ConsensusDocs, for example, this JV agreement, be used in concert with AIA forms of agreement? And I had in a brief email let them know that all ConsensusDocs can be used in concert with others, but you need to be careful when you mix forms.
Yeah, and I think we would certainly agree with that. The 298 is intended to be a self-contained document. It doesn't incorporate or specifically refer to AIA documents or any other family of forms of documents. Having said that, it happens, and so, for example, can you use, an AIA form to sub out the design or to subcontract? Certainly, you can always do that. You just, as was noted, you have to be careful. Some of the definitions and the terms don't line up precisely, and you can do it. You just have to be careful about how you do it to make sure that the documents are internally consistent.
Okay, we did have a couple more questions that just came in. One of them is from Wendy, said you mentioned some non-delegable items. Could you provide some examples of items that are typically non-delegable?
Certainly. The concept there being, though, that it's less about frankly, the answer is it could be anything that you wanted it to be. The project manager is tasked with, frankly, the day-to-day affairs of performing the work on the owner agreement, scheduling, ordering, long lead time items, all the things inherent in that. And so there's not intended to be any sort of limitation on that as a default setting. Having said that, there may be items that either that the executive committee just doesn't want to delegate, given the nature of a particular project or the unique circumstances to it, that maybe there's a particular piece of big equipment that they want to take out of the hands of the project manager and say, that should really be an executive committee type decision on which vendor we go with or the terms of that particular contract. Kerry, do you have any other?
Well, I think another example, and it probably is covered in a number of different aspects of the agreement, but where you're using a line item approach to this, to the divvying up of the physical scopes of work of the joint venture, and where for instance, the managing joint venturer may well be one of those line item subcontractors. It may be that the management on behalf of the joint venture of that managing joint venturer's scope of work would be something that the executive committee wants to hold on to, or that the other joint venturers wish to be handled and closely supervised by the executive committee. In that sense, would not be delegable then either to the project manager or the managing joint venturer.
But in the agreement itself, there isn't a menu of options. I mean, there's nothing listed. There's just a placeholder that if that is an issue on that particular project, there's a place to deal with it.
And that place is in Article 4.5 where there's a blank.
Wonderful. Another question we have is, does the 298 address the hiring of subcontractors? For example, is it okay for the JV to hire, or are they only hired directly by a joint venturer for their scope of the work? And that was from Blythe.
I think the default is that joint venture entity hires the subcontractors. Obviously, where you get into a line item type of joint venture, then that the posture of that changes just a little bit. But technically, the joint venture entity is subcontracting to the trades itself.
Yeah, that's certainly the case. I mean, the subcontract would be between the joint venture entity and the third-party subcontractor, and those payments are made, as we looked at in Exhibit B, pursuant to the amounts owed under those particular subcontract agreements. And as Kerry said here, if in the line item context, again, there would be a subcontract between the joint venture entity and the particular joint venturer. And in that context, the terms have to be agreed to by everyone, just so that nobody is getting a better deal in a line item context. But to answer the question, it's the JV entity, and that would be a responsibility of the project manager to implement that as part of the completing the work.
Great. Another question, this one's from Andrew, is can you describe some of the key differences in the structure of an operating agreement for an LLC versus a joint venture?
That's a great question. It's a question that we obviously struggled with as we moved on to developing the LLC form of joint venture agreement, which we're expecting out one of these days. The bulk of those types of issues arise from the statutory constraints and requirements that surround the use of an entity such as an LLC or a corporate entity or any other legal entity other than the joint venture. A number of requirements for documentation, the operating agreements, and the certificates and such that go along with that obviously get kind of wholesale brought over into the operating agreement so that they hopefully reflect accurately the predominant settings on the LLC statutes in the various states, obviously. And it's one of the things that we will point out in the guidebook when that document is published. But there's a variation from state to state in exactly the details of the requirements for LLCs and what they call certain relationships, how they're named and how they're dealt with. But there's a fair amount of uniformity in that, and we tried to capture that as we worked on that second agreement.
Great. I have another question here from Michael, and it says, how does this FOA, I'm assuming he means form of agreement, compare to AIA C-101? I don't know whether or not you're familiar with that form, but it's a question we have.
Yeah, not off. If you tell me the name of the agreement, we could probably tell you.
Okay. Well, that's one we could look up offline then. Or, Michael, if you're still on the line, if you want to type in the box the name of that AIA C-101, that would be great. And I'm not seeing any other questions here.
If it's the joint venture side of things, I mean,
Michael just
all of
responded.
the issues. What's that?
I'm sorry. Michael just responded that it's the joint venture agreement for professional services. So for design professionals, it looks like.
In that sense, I don't think it would be a fair comparison because that's doing something other than what this is doing, primarily chasing a particular project to be awarded the contract and then divvying up the responsibility on how that's handled. I guess as a segue, I mean, we have as ancillary documents to this teaming agreements in the just a general teaming agreement and a teaming agreement in the design build context. It may be a better comparison to some of those forms, but that's not one that we particularly accounted for in drafting this one. I know that.
Wonderful. Well, I'm just looking through to make sure I didn't miss anyone here, and it's not looking like it. And let the folks know that they can certainly always contact us at ConsensusDocs if they have additional questions, and we can get a hold of Kerry or Kory, or feel free to email them directly. I want to thank you, Kory and Kerry, very much for a very informative presentation, and I want to thank all of our participants for joining us today. We really hope this webinar helped you learn more about contracting for joint ventures and how the ConsensusDocs 298 joint venture agreement can help you with your projects. ConsensusDocs are the only standard contracts written and endorsed by 37 leading design and construction industry associations. Every ConsensusDocs contract was crafted and reviewed by a team of professionals with hundreds of years of practical experience representing all stakeholder interests. Should you need additional information, please feel free to visit our website at www.consensusdocs.org. Send us an email at support@consensusdocs.org or call our toll-free number at 866-925-DOCS. That's 3627. And just as a reminder, we will be sending out an email. It will take us a couple of business days to get the recording all cleaned up and such, but we will be sending you an email with a link to the recording and the PowerPoint. We've had several people ask for sample copies of the JVA. If you want to do that, feel free to visit our website under our resources page, and you can request a complete sample copy for your review purposes only. That would be great. And so with that, unless Kory or Kerry, you have anything else?
No, thank you, everyone.
Yeah, thanks very much.
Thank you all, and this will bring our program to a close, and I hope everyone has a wonderful afternoon.